I'm Advocate Nikita Pandit and I will be speaking on the patent laws in the USA. You're watching Legal Bytes. The main objective of this video is to understand the legal provisions related to the patent in the USA, what can be patented, what cannot be patented, how to file for the registration of patents, and some case laws. Now, patent is a right which is given to an inventor for the invention where he can perform certain acts to the exclusion of others in relation with that invention for a period of 20 years. Now, invention is something that is new. It is something which has never been known before or never been done before. It may offer a solution to some technical problem. Now, by exclusive right to the inventor means the patent holder gets a right to exploit the use of his invention by making money out of it, such as by selling, by distributing it, by using it. No other person has the power to do this without the permission of the inventor. Now, in the US Constitution, the power is given to the Congress to do all such acts which are necessary for promoting the science and useful arts under Article 1, Section 8, Clause 8. By using this power, the first law for protecting the patents was passed in the year 1790. A revision was made to this in 1953 and this became a part of Title 35 of the US Code dealing exclusively with the patents. In the year 1999, the Congress also passed American Inventors Protection Act and again the law was amended. Section 101 of the US Code explains what are patentable inventions. Now in USA, the definition of invention also includes discovery. It is anything that is new and useful, but it should be a process or a machine or a composition or manufacture. Section 102 provides for what cannot be patented. Now, when any such invention is already known to the public in USA, or if the invention is already patented or given for the publication in the USA or any other country, or if the invention is already been used by the public for more than a year before the date on which the applicant filed the application, it cannot be patented. So, in other words, the invention should not be a prior art. Now, it is also important to know what does not constitute a prior art. So, if the disclosure statement is made within 1 year or lesser than a year before the application date, and such statement is made by the inventor himself, or in case of joint ownership, any of the joint owner, it is not prior art, so it can be patented. Now, apart from newness, that is novelty, Section 103 provides that the invention to be patentable must be non-obvious, which means any person who would be having the technical knowledge of that field would not have thought of such invention. Now, this poses as a test to determine the difference between prior art and invention which has to be registered. So, if in such invention any biotechnological process involving alteration of the cells of an organism is used and the complete new composition is made out of it, it is called non-obvious only if it becomes the part of the application of that invention or separate application is filed for that on the same day as that of the invention application. It is also rendered non-obvious if the same person has invented both the new invention and the new composition caused while making the invention. Such composition could have also been assigned to the inventor to make it non-obvious. There is a case, Bilski versus Kapos. Now, the patent was filed by the petitioner for the method that they had developed to determine the risk for the buyers and sellers, which was due to the price changes in the commodity markets. Now, they made certain steps to lower the risk and came up with a mathematical formula solving a mathematical problem. Now, this patent was rejected, it being an abstract idea, and the appellate board also upheld the same. The Supreme Court also affirmed. Now, when invention is the process, it must be tied to some machine or an apparatus or transformed to some state or a thing. The laws of nature, physical phenomenon, abstract ideas are not patentable. Now, in order to file an application for the patent, the inventor has to follow the steps which are given in section 111. A written application has to be submitted to the director with the appropriate fees. It is required to submit the provisional specification describing the invention and how to use that invention in such a way that a person who is skilled in that field should be able to make it or use it. The best way of making it or using it should also be mentioned in it. Now the inventor should write what exactly he is claiming under the patent, with what are the rights that he is claiming. Now whenever it is necessary to describe the invention in a better way, the inventor also has to provide the drawings of that invention. The director is given a power to demand the drawing if he feels that it is necessary, and he has to give a 2 months notice for that. The director can also ask for a model specimen or ingredients that are to be submitted. Now the inventor has to give a statement on oath that he believes that he is the original inventor of the subject matter, and he should also mention his nationality, that is the country. Such oath must be taken before the authorized officer of the state. The assignee or the agent of the inventor can also do these acts. Now the most important right here is the right of priority. Section 119 of the Title 35 of the US Code, if a person has filed for a patent before the application in some another country which is a member of the convention or treaties where the US is a member, the person can enjoy the priority date as the date of previous application, and that will be considered while giving him the patent if such application was made within 12 months, because otherwise it would constitute public use if it is used for more than 1 year, which is not patentable. The inventor in this case has to get the details of the previous filing and the records which are with that authority to claim the priority date. Now if the priority is not claimed, it can be considered as wiped off by the inventor. If many separate inventions are claimed from one application, the director can also ask to file division, that is separate application, but the inventor can use the filing date same as that of the original application under section 121. Now after 18 months, the application is published as per the directions of the director under section 122, before which it is kept confidential. Now if the application is in compliance with the law, the director may issue the patent to the applicant. If however there is any rejection or objection, the director has a right to inform the applicant, and accordingly the inventor can make non-substantial amendments. Within 30 days to 6 months, as the director decides, if the applicant fails to react to such notice, it is implied that he has abandoned the patent. Appeal can be filed after 2 rejections to the Board of Patent Appeals and Interferences. Now appeals we understand, but what are interferences? Interference is when the application is such that it interferes with the patent right of already existing patent, or with an application where the registration is pending. The patent rights can be transferred by a license or an assignment. Now whoever makes, uses, sells or offers to sell an invention or a main part of it specially required for the patent to work without the consent of an inventor, it is an infringement. The defense against infringement is the prior use. It must be shown that he has been using it commercially even before the invention, and such use was at least 1 year from the application date or publication date as per section 273 of the code. Now there are certain remedies available under Title 35 of the US Code against the infringement, and section 281 provides for the civil remedies. Now the burden of proof regarding proving that there is no obviousness or newness in the patent, it is on the person who says so. The patent is presumed to be a valid patent. Section 283 to 285 provide for the kinds of remedies. The remedy of injunction can be claimed to bring a stay on the violating acts. Damages can be claimed to compensate the inventor along with interest, and costs and court fees can also be awarded if the director or the court feels so. The limitation to file the complaint is 6 years. Now, in one case, eBay versus Merck Exchange. eBay, a website, let the other brands put their products on their website for auction. Half.com was a wholly owned subsidiary of eBay and undertook the operation of similar website. Merck Exchange wanted a license for their patent and to both of them, but they did not reach an agreement. Merck Exchange filed a suit for permanent injunction for infringement of their patent. District Court upheld the infringement, but the decision of the jury denied it. Now, Court of Appeals gave an opposite decision. It was held that permanent injunction was appropriate. However, Supreme Court again reversed their decision. So, they gave a test which is to be fulfilled to give a permanent injunction, that is irreparable injury to the plaintiff, remedies by the law such as compensation and balance of hardships. The decision of injunction must be done using the principles of equity. Now, these are certain important provisions regarding the patent law in the USA. Thank you.